Good morning, everyone. I am Vandari from the Western India Regional Council of the Institute of Cost Accountants of India. Today's faculty is Mrs. Nidhi Hora. Nidhi Hora has completed her LLB from Government Law College, Mumbai, and she is also company secretary. She is delivering the lecture in various professional courses like CMA, CS, and other professional courses also. So, and she is the regular faculty for our Institute of Cost Accountants of India for the subject law and ethics. Now I request Madam to start the session. Thank you.
Good morning, everybody. I'm Nidhi Dhruv, and as Vanzari sir said, Nidhi Vora was my maiden name. So this is Nidhi Dhruv, and I am pleased to take this lecture online, this session online. And I would like to thank the institute, the ICMAI Institute, for giving me this opportunity to address all the students all across India. And I would also like to thank Connect Easy, Mr. Viraksha, for helping us with all this. Uh, Thank you so much. Uh, I will be taking law and ethics. Um, Everybody who's attending the session, I will want everybody to carry this book with you, your module, laws and ethics ka module. Everybody should keep with them. So anything, any query arises, you can check in that as well. And I'll be taking today part A of your laws and ethics syllabus. So commercial laws part A, we are going to start today. So 30% of your syllabus is covered in commercial law. So we'll be finishing commercial laws today. uh, all right, so I'll start with the laws of contract first. Now law of contract is something is which is not very new for you. I believe ये आपने थोड़ा फाउंडेशन में भी पढ़ा हुआ है, and this you have studied in your undergraduation college, that is 11 12 junior colleges में भी किया हुआ है थोड़ा बहुत. So it's not very new for you, but still in the depth we are going to do while doing in the professional course like CMA. Okay, so we'll start with this law of contract. And all the students, anytime if you feel I'm going fast, or you don't understand anything, you please free to feel free to comment in the YouTube. I will definitely address your questions, your queries. Okay, so let's start. Let's begin. So law of contract. First of all, the term contract, we hear in our day-to-day lives also. Correct? So contract is term in use. It's for small things like when you buy vegetables from your vendor, vegetable vendor, or fruits from your fruit vendor. That is also when we are entering into contract. You are paying for something and you are getting something in return. Correct? So that is also kind of a contract. But we are used to hearing the word contract in business life only, and जब ऑफिस में बैठ के हम कॉन्ट्रैक्ट करते हैं, that is when you feel that contract is entered. Correct? So what exactly you know about the contract? First of all, think about that. आई नो सब लोग को ऐसा ही है दिमाग में पिक्चर के ऑफिस में बैठ के जो बड़े बड़े बिजनेस डील्स करते हैं वो ही कॉन्ट्रैक्ट होता है. तो नो, एज आई सेड, स्मॉल डे टू डे ट्रांजेक्शंस आर आल्सो कॉन्ट्रैक्ट. जैसे आप वेजिटेबल्स खरीदते हो, फ्रूट्स खरीदते हो, कोई शॉप में से खरीदते हो, व्हेन यू ट्रैवल बाय ट्रेन और बस, that is also when you are entering into contract. When you buy ticket and they provide you service, and rules are also written on the ticket if you see on the back side of the ticket. So all those are contract actually. Okay. um, Now let us understand about the rules of the contract. And when I say the term contract, do you think it is same as agreement? I mean, a lot of words in substitute the word contract with the word agreement. बहुत लोग ऐसे बोलते हैं agreement contract सब एक है, या agreement के बदले कभी contract बोल दिया, contract के बदले कभी agreement बोल दिया. तो do you think it is same? Let us see. आज आपको समझ में आ जाएगा कि how it is different. It is not same. It is quite different. So how it is different? Before going to that topic, let us see some introductory part of Contract Act. So Indian Contract Act, it was enacted by Parliament of India way back in 1872. Okay, when Britishers were there, that is time Contract Act was made. It is quite an old act. It commenced on 1st September 1872. Now these details you need to remember for MCQs. आपको MCQs भी पूछे जाने वाले हैं आपके एग्जाम्स में, तो ये डिटेल्स आपको MCQ पर्पस के लिए ध्यान में रखनी है. टोटल 238 सेक्शंस है, and it extends to all over India except Jammu and Kashmir. Okay, so ये small details भी आपको ध्यान में रखनी है. We'll go ahead. The Indian contract consists of the following two parts. General principles of law of contract is covered in first 75 sections, and in other part of the Contract Act, section 124 to 238, special contracts are covered. We'll be doing both the parts today in brief. So what is a contract? So contract, as you can see on the screen, is a voluntary agreement, arrangement between two or more parties that is enforceable by law as a binding legal agreement. So this is a definition of contract. This says that voluntary arrangement between at least two parties. Minimum two parties are required. Okay. And then a binding legal agreement. So as in the beginning I addressed, agreement, legal agreement जो होता है, even if it is said as legal agreement, it will not mean same as contract. It has to be enforceable by law. The legal agreement has to be enforceable by law to become a contract. तभी ही वो contract consider होगा. All right. An agreement which is legally enforceable alone is a contract. उसके अलावा any other legal agreement will not be considered as contract. All right. So what is enforceability by law? That all we'll see in a while. Agreements which are not legally enforceable are not contracts, but remain as void agreements. What are void agreements? We'll see those things also in detail. And are not enforceable at all, or as voidable agreements which are enforceable by only one of the parties to the agreement. ये bifurcation भी हम आगे जाके देखेंगे. So what it is saying is agreements which are not legally enforceable, जो enforceable by law नहीं है, those will remain void agreements. Void means invalid. Invalid agreements consider होंगे, and it will not be enforceable in the court of law. When I'm saying enforceable means it will not be acceptable in the court of law. That is what it means. Or as voidable agreements. या फिर उसको कैसे treat किया जाएगा? Either one as void agreement or second as voidable agreements, which are enforceable by only one party. Voidable agreements is some agreements which are not entered with the free consent of other party. एक पार्टी का कंसेंट है और दूसरी पार्टी ने कंसेंट नहीं दिया, उसका फोर्सफुली कंसेंट लिया गया है. So when second party, other party is not giving free consent, then the party whose consent is not free will have liberty to decide whether he wants to continue with the contract or not. And that is what is voidable agreements. Okay. And that is enforceable by only one of the party to the agreement. That is the party whose consent is not free. He will decide whether he wants to continue with the contract or not. So ये partly हम बोल सकते हैं enforceable है, but complete validity तो नहीं मिलता. ये depend करता है the party whose consent was not free उसके ऊपर. ठीक है. All contracts are agreements, but all agreements are not contracts. Very very rightly stated statement. ठीक है कि सारे agreements contracts agreements है, because for entering into contract we require agreement. पहले agreement तो होना चाहिए, वो starting का step है. But when agreements are enforceable by law, that is when it becomes contract. So all contracts are agreements, but all agreements are not contracts, because when it misses the step of enforceability by law, it will not become contract. It will not be called as contract. So this statement is rightly stated. Many times in your exam, this has been asked. This statement ke isko explain karo. All contracts are agreements, but all agreements are not contracts. Explain. So when you are explaining this entire procedure of entering into contract, you have to explain. So while entering into contract, agreements is one of the step. Okay, when you enter into agreement contract, agreement is one of the step. पहले agreement होगा, and when those agreements are enforceable by law, that is when it will be considered as contract. That is why the statement is very rightly stated. How you need to explain this? When we go ahead with the Contract Act, you will understand it better. Let's move ahead. So this procedure we are doing now, how the contract is entered into. Okay, this procedure for entering into contract, the steps for entering into contract. The first step is proposal, offer. One of the party will make an offer to other party that I am willing to enter into contract for you for so and so purpose. Example के साथ समझते हैं. Let's take an example. If I want to buy a mobile phone from my friend, a second hand phone. Okay, so I am making an offer to my friend saying that, do you wish to give me your phone in so and so amount, in 5,000 rupees, say for example. So I am making an offer, a proposal to her that, do you wish to give me a phone in 5,000 rupees? Which is upon her, my friend, to accept or reject. If she accepts that proposal, it is said as acceptance. So when one party makes an offer and other accepts to it, it results into promise between two parties. All right. So this is very simple to understand. One party makes proposal and other accepts to it. And if the acceptance happens, the promise between two parties will happen. All right. So the definition, let's understand more in detail about the offer part. Offer is something, when I said I'm making offer to my friend, so I am signifying my willingness to do something or not to do something. It can be negative way also. That is, I make proposal to my friend saying that, you please don't enter into contract. You don't give your phone to other one. If you don't give, I'm ready to buy from you. So I'm asking her to abstain from doing something, not to do something. Okay. So offer definition, the contents of offer requires two things. Signifying, one party will signify his willingness to do something or abstain from doing something with a view, and second part is with a view to take the assent, the consent of other person. If the willingness is signified with the view of taking consent of other person, then only it will be considered as offer. Otherwise, it will not be considered as offer. How? I'll explain. If I am asking my friend, do you wish to give me a phone for 5,000 rupees? Okay. I'm signifying my willingness to buy her phone. Okay. But with a view to my sentence is such framed in such a way that I am asking her to give consent. Okay, I am asking for her consent. If I would have said just that, अरे यार, आई एम प्लानिंग टू बाय न्यू फोन, अभी सोच रही हूँ कि कौन सा लूँ, आई एम थिंकिंग व्हाट फोन टू बाय. If I just signifying my plans, I just suggest my plans to do something, then it is not an offer. But if I am signifying my willingness, the way I told my friend, with a view to take her consent, then it will be considered as offer. So two things required: signifying willingness to do something or not to do something, that is abstain from doing something, with a view to take the consent of other party. So you can see the definition over here in section 2A, it is mentioned. And the other party may accept your proposal or reject your proposal. If the other party signifies his assent, uska consent usne signify kiya, then the proposal is said to be accepted. Very simple thing. Okay. Then other one is promise. Promise is also simple, we understood. When one party makes an offer and other accepts to it, then promise between two parties happen. Okay. A proposal when accepted becomes a promise. In simple words, when an offer is accepted, it becomes promise. Okay. When offer plus acceptance, it results into promise. Promiser and promisee. One mistake in this slide, please make a note of it. It's not promise, it's promisee. Okay, promiser and promisee. One more e will be added. So when the proposal is accepted, the person making the proposal is called promiser. So in my example, previous example, when I made proposal to my friend, I am a promiser, and the person accepting the proposal, he is called promisee. Not promise, here one more e will be added. Okay, so make note of that. So in my example, I am a promiser, I am the promiser, and my friend to whom I made the offer, when he accepts to it, it will be called promisee. Are you all clear with this? So offer, acceptance, and promise, and the parties are called promiser, promisee. So this is very important to understand. We are doing the procedure of how the contract is entered into. Now we understood offer and acceptance results into promise. When now promise alone is not the same as agreement or contract, of course, we need something more to it. Okay, what do we require? We require consideration. What do we require? Consideration to enter into agreement. Only promise between two parties will not be considered as agreement. When it is supported by consideration, it will result into agreement. What is consideration now? That is your question. If in simple words I want to say, in simple words, consideration is something in exchange of something. One party is getting something and other party is also getting something. In my previous example, when I am willing to buy phone from my friend, I am going to get phone and the friend is going to get money. So both of us are getting something, phone and money. Both the parties are getting something. So they are exchanging something. So something in exchange of something is consideration. In simple words, if I say, in normal language, if you want to understand consideration, it's something in exchange of something. So promise, when supported by some consideration, it will result into agreement. But what exactly is consideration? What are the actual ingredients of consideration? We'll understand that also in a while. But for now, you understand that consideration is something in exchange of something. Both the parties must get something from the as a result of promise. Okay, and it will result into agreement. Now, agreement is not same as contract. That is what we discussed earlier, correct? So agreement, when enforceable by law, it will become a contract. When agreement is enforceable by law, it will result into contract. So the contract definition itself says an agreement enforceable by law is a contract. All right. So the main thing is enforceability by law. Agreement tak to theek hai, but there will be no value in the eyes of law. What if you have entered into agreement with someone? If I have entered into agreement, we exchange promise, the friends, me exchange promise with my friend saying that I'll buy a phone in 5,000 rupees. She said yes also. And then we exchange money also, money and phone also. And then if something happens, can I go to the court if something happens to the phone and she has taken money and her phone is not in working condition or something like that? Can I go to the court? No. If enforceability by law is not present, I will not be able to go to the court. Okay, so why do we require contract? What is the importance of contract? Is that it gives you right to approach the court. Only when agreement is enforceable by law, you can approach the court, you can go to the court. Okay, so enforceability by law is, in simple words, validity in the eyes of law. In the eyes of law, valid अगर कोई agreement है, then it will be considered as contract. So entire procedure, now let us understand. Proposal, that is offer. When it is accepted, it results into promise. Now promise, when supported by consideration, it will be considered as agreement. And agreement, when it is legally enforceable, it will result into contract. This is simple to understand कि legally enforceable है, contract हो गया. And the other arrow goes towards voidable agreement, which we discussed some time back, that if one party's consent is not free, if the consent was forceful, if I asked my friend to give her phone forcefully, like by blackmailing, if you don't give me your phone in this much money, in 5,000 rupees, I will tell your secrets to your parents, your family. If I threaten her like that and take her consent, then the contract, it will not result into contract. It will, only because free consent is not there, it will result into voidable agreement. Now what will be voidable agreement? Voidable agreement is, you, the party whose consent was not free, my friend in my example, will have a right to continue with the contract or cancel the contract. Even if I have threatened her, but if she feels the deal is fair for us, the deal is good for us, it's beneficial for her, she may continue with the contract. And if she decides to continue with the contract, it will result into normal contract. But until then, until she decides, it will become voidable agreement. That is, only one party, at the option of one party, it will be enforceable. That is, मेरे लिए, मेरे part पे, it will be enforceable. My friend can enforce on me anytime, but for her, it will not become enforceable until she decides whether she wants to continue with the contract or cancel the contract. So everybody clear with this? So when promise supported by consideration, it will result into agreement, and agreement when legally enforceable, it will result into either contract or voidable agreement. If free consent is not there, then voidable agreement. And other arrow goes towards legally not enforceable. If enforceability by law है ही नहीं, मतलब अगर validity in the eyes of law नहीं है, then it will remain just agreement. It will remain what? Void agreement. It will not be called as contract. It will remain just agreement. Void agreement. Okay. And void is invalid agreement. So let us have a look. Let us have a look at essential elements of a valid contract. So what do we require for entering into a valid contract? One is offer and acceptance. Okay. So what are we looking at actually? Enforceability by law की conditions देख रहे हैं हम लोग indirectly. ठीक है. मतलब essential elements में हम लोग enforceability by law till entering into agreement you understood very well. But when agreement is enforceable by law, it will result into contract, I said. So when it is enforceable by law, these are the conditions. When it is fulfilled, it will be considered as a enforceable by law contract. Okay. So for making an agreement enforceable by law, these conditions must be fulfilled. First is offer and acceptance. Valid offer and acceptance होना चाहिए. Second, legal relationship होना चाहिए. That is, the parties legal relationship का meaning इधर है, the one who are attending, please make a note. Legal relationship आपकी books भी आप साथ में रखना, उसमें legal relationship यहाँ पे mention करना. When I have mentioned that point legal relationship, I mean parties have intention to enter into legal relationship while entering into agreement. If while entering into agreement, parties have intention to enter into legal relationship, then only it will be considered as a contract, for which you can go to the court. So what is intention to create legal relationship? I'll give you example. If one kid, major kid, like but 19-20 year old kid, teenager, uh, tells his mom, rather threatens his mom, saying that you buy me a sports bike or else I'm committing suicide. Okay. So by saying so, he took the consent from mother, say for buying him the sports bike. Here, when mother gave the consent, do you think she had any intention to enter into legal relationship? So here we cannot say that there was intention to create legal relationship. Say for example, my husband promises me that I'll buy you a diamond necklace one day, and he doesn't buy. He doesn't, fulfill his promise. Can I sue him for that? No. When he made a promise, and even though consideration was there and everything was there, can I say there was any intention to create legal relationship between parties, between husband wife? No. So when I'm saying intention to enter into legal relationship, I mean that while parties are entering into some legal, it's not necessarily कि commercially होना चाहिए, कि business relationship ही होना चाहिए, but if the parties have intention to enter into legal relationship, the test for determining whether the intention was there or not is, if one party doesn't fulfill the promise, if other party is likely to suffer real loss, then we can say that the party had intention to enter into legal relationship. Example, if I enter into contract with a firm for working for them, okay, and then they do not pay as per the contract, okay, I will suffer loss, I will suffer actual loss. I've worked for them and I'm not getting the returns, proper returns. So there was intention to create legal relationship between parties. So such intention should be there. All right. Third one, consensus addendum. This is a maxim. Indian law is not self-made. Sort of, we can say, lot of our legal principles are derived from other countries' laws. So when some Latin and Roman culture say certain legal principles are derived in India, and it is derived in their language only. The legal principles are derived in their language only, in Latin and Roman language. So those legal principles in Latin and Roman language are called maxims. Okay, so consensus addendum is kind of a maxim, a legal principle derived from Latin. Okay, in Latin language. So consensus addendum in English, it means um, both the parties must get something. That is, consensus addendum means both the parties must have same things in mind while entering into contract. Okay, the meeting of minds must be there between parties. That is, they must agree on the same thing with the same intention, with this, in the same sense they must agree on the things. Say for example, I'm buying a sari from a shop, and not from a shop. Say for example, I'm a wholesaler and I'm buying from a manufacturer, and I entered into contract for supplying me 1,000 saris. Okay, when I entered into contract, I meant silk saris, and the manufacturer understood it to be some other fabric like chiffon saris. Okay, and we never mentioned in the contract what fabric of sari. Okay, so we both made mistake in understanding, and accordingly, of course, price भी differ हो जाएगा. So there was no meeting minds of between parties, meeting of minds. दोनों ने same intention से same समझ के contract में enter नहीं किया है. Okay, so that is, there was no consensus addendum between parties. One party thought it to be something else, other party thought it to be something else. Then what is the point of agreement? When we say agreement, both the parties must agree on the same thing. If they do not agree on the same things, there is no meeting of minds between them, then we can say consensus addendum is not there. And that is very important element for entering into contract. एक ने कुछ समझा, दूसरे ने कुछ और समझा और contract में enter किया, तो of course उसका फायदा नहीं है. So consensus addendum means meeting of minds must be there between parties. Then free consent must be there between parties. When I say free consent, 5 things You can see in detail. Since it's a crash course, I've not entered everything in the slides, okay, but you can very well see in your books. Free consent in detail, it is given. So free, you can keep your book, you can refer your book while I'm discussing free consent topic, okay. So free consent must be there. Free consent means the consent must be freely given by both the parties, not forcefully given. When the consent is given in 5 ways, it is said to be forceful consent, not a free consent, okay. What are those 5 things? First is coercion, coercion. Coercion. When the consent is given by coercion, means forceful way. So doing anything which is forbidden by IPC, or threatening to commit anything which is forbidden by IPC, if by doing that the consent is given, then taken, given or taken, then it is not set as free consent. It is the consent by coercion. So consent by coercion is not a free consent. So when I'm saying committing anything which is forbidden by IPC, IPC means Indian Penal Code, criminal law है इंडिया का, उसमें जो भी acts mention किए like murder, rape, kidnapping, etc. तो वैसे जो भी क्रिमिनल एक्ट्स कमिट करके या थ्रेटन करके कि ये मैं करूंगा, मैं मर्डर कर दूंगा या कर दूंगी या किडनैप कर लूंगी इफ यू डू नॉट एंटर इनटू अग्रीमेंट विद मी, ऐसा थ्रेटन करना या एक्चुअली कमिट करना, किडनैपिंग, मर्डर एक्सेट्रा, एंड देन एंटर करना किसी के साथ अग्रीमेंट, द कंसेंट इज नॉट सेड टू बी फ्री, इट इज टेकन, कंसेंट इज टेकन बाय कोवर्जन. If consent is taken by coercion, then it is not a free consent. Second one, if the consent is taken by undue influence. If consent is taken by undue influence, it's not a free consent. Undue influence is when there are two parties, one party is in a dominating position over other. So other party is inferior and one party is in a dominating position over other. And he uses that dominating position to take unfair advantage of other party. Okay. So example, there are doctor and patient relationship between two parties. Patient has disclosed some of his confidential or his about his disease to the doctor, and he doesn't want, the patient doesn't want the world to know about it. उसको नहीं चाहिए कि सबको दुनिया में पता चले. So he wants doctor to keep it confidential. Now doctor knows about this secret of the patient and he says, you enter into this agreement with me. If you do not enter, I will disclose about your disease to the world. मैं सबको बता दूंगा. तो इस तरीके से जब ये सीक्रेट पता है डॉक्टर को, तो वो एक डोमिनेटिंग पोजीशन में आ गया और पेशेंट इंफीरियर पोजीशन में आ गया, एंड डॉक्टर ने अपना डोमिनेटिंग पोजीशन यूज किया अनफेयर एडवांटेज लेने के लिए, टू टेक द अनफेयर एडवांटेज ऑफ पेशेंट. देन he is said to have taken the consent by undue influence, and it is not a free consent. Third one, when the consent is taken by fraud. Fraud तो आप सबको समझ में आता है, cheating. But in the with the angle of contract, how to understand fraud? So while entering into contract, if you do not disclose right facts, if you have concealed something, if you have hidden something from other party, so when contract is entered by stating false facts, untrue facts, false facts बता के अगर contract में enter किया है, तो fraud से contract में enter किया, we can say like that, and the consent when taken by fraud, it is not a free consent. Now one more thing comes here. Does silence amount to fraud? Stating false facts with the intention to deceive other parties, fraud. Okay, so when you say wrong facts with the bad intention, with the intention to mislead, deceive other party, it's fraud. So do you think when not saying anything, not stating false facts, but not saying anything at all, सिर्फ चुप रहना, कुछ गलत पता है कुछ पर वो बारे में बताना नहीं, you keep quiet about something, does that silence will also amount to fraud? Do you think so? Yes, silence amounts to fraud, but not always. It amounts to fraud only in 2 situations. Listen carefully, understand carefully, everybody. Silence amounts to fraud only in 2 situations. One is when your silence is equivalent to speech. That is, example देती हूँ इसके लिए समझने के लिए. I went to buy a horse. Okay, I'm willing to buy a horse from a person, And I say to the seller that if you do not say anything, I will understand that horse's sound बराबर है, उसका health वगैरह भी बराबर है. I will understand the horse to be sound. And he keeps quiet.
हेलो विराट सर.
Hello.
Yeah, please start.
Yeah, is my voice audible?
Yes, yes, yes.
Okay.
You can share the screen as well.
Just a second, huh? Yeah, I'll do that. Yeah, is it visible now?
Yes, yes, yes.
Okay. Okay.
Yes.
So, sorry for the inconvenience, everybody. So we were doing essential elements of a valid contract, and we did offer and acceptance and legal relationship. Okay. So in these slides, you can understand again that what is offer and acceptance and legal relationship. The third point was consensus added in, that is meeting of minds between parties. That is also covered over here. Now we were discussing free consent. Okay, free consent is basically uh, not having forceful consent. Both the parties must give their consent freely. Okay, so in that we discussed when the consent is obtained by coercion, it is not a free consent. Second one, we discussed that when the consent is obtained by undue influence, it's not a free consent. And at the same time, when the consent is obtained by fraud, that is also not a free consent. And in that we were discussing when silence amounts to fraud. So first one was silence amounts to fraud when the speech silence is equivalent to speech. And that for that horse buying example I gave. Okay. The other second point when silence is equivalent to speech is when there is a duty to speak. So when you enter into insurance contract with insurance companies, say for example fire insurance or marine insurance or your life insurance. Say for example you are taking some life insurance policy. While taking that, you need to disclose about all the diseases you have. Okay. When you do not disclose about your disease, when you do not disclose about your disease, you have there is a duty to speak about your disease. Okay, when you enter into life insurance policy, if you do not disclose about that, when you have kept silence at that point of time, it will amount to fraud. And later on, if that insurance company comes to know about the disease you have kept mum about, then they have right not to cancel your policy, not to issue your policy. Okay, so when there is a duty to speak, you have to speak. And when at that time you keep silence, it will remain definitely amount to fraud. Okay, then fourth one is misrepresentation. Now misrepresentation is also quite similar to fraud. Okay, uh, fraud is making false statements with the intention to deceive other party, mislead other party. But when the contract is entered on the basis of false facts, but what with not bad intention, with good intention, means not with a bad intention, believing it to be true, making false statement. I will give you example. I have gone to a shop to buy a flower vase. Okay, and I asked the shopkeeper whether it is unbreakable. ये टूटेगा तो नहीं, whether it is unbreakable or not. So he thought, उसने जहां से buy किया था, the person from whom he bought, उसने बोला था कि yes it is unbreakable. तो accordingly he also said it is unbreakable और कभी उसके shop में टूटा नहीं था. So on that basis, believing it to be true, believing what he's saying to be true, he said that it is unbreakable vase. Okay, and I bought it. The very next day when I got it home, it broke. टूट गया मेरा जो फ्लावर वाज था वो. So I have right to sue him saying that भाई ये मिसरिप्रेजेंटेशन किया तुमने, जो फैक्ट्स बताए वो गलत फैक्ट्स पे, you stated wrong facts and took my consent. So I don't want to continue the contract. I want my money back. So that is misrepresentation. The consent is not free because it is based on wrong facts. But the other party have no fault, matlab have believed the statement to be true and stated. but still the one who bought it, I mean the other party whose consent was not free because it was based on false facts, have right to continue with the contract or cancel the contract. That is why it will be considered as voidable agreement. Okay. Till now whatever points, and misrepresent consent is taken in these four ways, the contract becomes voidable. Voidable agreement become, you can see in this.
Madam, you are not audible. I think some net problem is there. Kindly check the net. Connectivity problem is there.
Hello. Can you hear me now?
एक मिनिट हा. बघू शनिवारी.
Hello, Ansari sir.
Yes, yes, madam.
Can you hear me? Sorry for the
Yes,
inconvenience,
yes.
everybody. The internet problem is there.
नाही नाही घरी. यू कॅन स्टार्ट मॅडम. हां. हो घरूनच करतोय ना. हां व्यंकटेश बरोबर. त्यांना घ्यायला सांग ना, मी त्यांचा नंबर पाठवतो तुला. अनुपम वाढतलंय, तो सिलेबस संपलाय.
Hello.
येस मॅडम.
Yeah. Can you hear me, right?
येस येस यू आय कॅन. येस.
Yeah. Okay. So
हां बोल.
now the fifth part comes mistake. When the consent is taken by mistake, then the consent is also not a free consent. Okay. So the consent is taken by mistake. We can say there is a consent by mistake. When there is no consent is added. You can see in the same slide when the consent is by
एक मिनिट हा.
when the consent is
इज ब्रेकिंग.
the
मॅडम
voice is breaking.
क्लिअर.
हाँ अभी इंटरनेट का थोड़ा
डिस्टर्बन्स.
इश्यू है. अभी सुनाई दे रहा है? हेलो.
हां नाउ इट्स ओके. येस कॅरी ऑन.
When the consent is by mistake, when there is no consent is added in, we can say consent is by mistake, and the consent is not a free consent. The other ingredients are capacity or competency of parties. Is my screen visible? Mandari sir?
Not yet, not yet. Please share the screen.
Host disable the participant screen sharing. Virag sir, you need to.
You are your co-host. You can do.
But since I left, I think नहीं हो रहा है. Host disable participant screen sharing आ रहा है.
Please re-log in one more time. It's showing you are co-host.
Hello.
Yes.
Yeah, please make me the host again. I'm not the host now.
It's showing you are co-host at present. So meanwhile, you can log in from the mobile as well, and you can share the screen later as and when possible.
Hello, I could not hear. Yeah, now I can share.
Meanwhile, I'm to
Is my screen visible now?
log in from mobile as well.
Sorry.
You can log in from mobile as well simultaneously, and as and when it is possible to share the screen, you can do screen sharing as well. Yeah, so you can now share the, you will be able to share the screen and you can start the session as well.
Okay.
Yes, screen is visible now. Nidhi ma'am, you can unmute yourself and start the session.
Yeah. Sorry for the inconvenience, everybody. So we were uh, on the hello. Hello.
Yes, yes.
Yeah. So let us continue with the essential elements of a valid contract. So we were on free consent part. So when the consent is taken by coercion, undue influence, fraud, misrepresentation, the contract, the agreement will become what? Voidable agreement. All right. So it is considered as voidable agreement. And the last one is when the consent is taken by mistake. It will be considered as it is without consensus addendum. The point which you can see above this free consent point, consensus addendum, which we discussed just some time back. That is, if there is no meeting of minds between parties, If the parties do not agree on the same thing with the same meaning, we can say there is a mistake in understanding the agreement, and then there is no free consent. All right. So when the consent is obtained in this 5 manner, coercion, undue influence, fraud, misrepresentation, or mistake, the consent is not a free consent, and the very, very important ingredient required for making a contract will not be available. All right. So free consent is very, very important ingredient. The other one, fifth one here we are discussing is capacity or competency of parties. There has to be capacity or competency of party to enter into contract. So which parties are not competent? Let us discuss that first. Which parties are not competent to enter into contract? Party which are minors. Okay. See, you can see in the section 11 part, the Indian Contract Act specifies that every person who is competent to contract is provided. If he is the age of majority, or he is of sound mind, and is not disqualified from contracting by any law to which he is subject. So for becoming a competent party, you are supposed to be connected 3 ways. You must be eligible in 3 ways. How? First of all, you should not be a minor. So every person who is major is considered as party competent to enter into contract. Secondly, those who are of sound mind. What do you understand by sound mind? Those who have solved the mock test will come to know that mock test में question ऐसा था कि what is sound mind? So you must know what is sound mind also. Only sound mind person can enter into contract. So who is person of sound mind? The person of sound mind is them who can understand the terms and condition of the contract and the consequences of it. While entering into contract, what is the contract? What are the terms and conditions, and what will be the consequences of the contract? Everything they must be able to understand. Okay. So that is the person of sound mind. The person must be major, that is above 18 years, and must be of sound mind. And thirdly, they must not be disqualified from contracting by any law to which he is subject. So to which he is subject means any law which is applicable upon party. The party must not be disqualified from the law to which he is applicable upon him. So party must not be disqualified means I will give you some examples of it, like alien enemies. Alien enemies are the parties who are the citizen of a country with whom India is at war. इंडिया का जिस कंट्री के साथ वॉर चल रहा है, उस कंट्री के साथ इफ हम उस कंट्री के सिटीजन के साथ अगर हम कॉन्ट्रैक्ट में एंटर करें, देन दोज आर एलियन एनिमी फॉर अस. द country with whom India is at war, citizen of that country becomes alien enemy for us. So alien enemy के साथ we are disqualified from entering into contract. Then from second one is insolvent person. If we are entering into contract with insolvent person, then as per the law we are not, the insolvent person is not qualified to enter into contract. So insolvent person as per Insolvency Act is disqualified from entering into contract. Then other one is convicts. Those who are in the jail, those who are suffering from imprisonment period cannot enter into contract. Okay, they are disqualified from entering into contract. And the foreign ambassadors, the ambassadors means foreign representatives of India. Diplomats and foreign ambassadors, when they go to other country and represent India, they cannot enter into contract with other country, the government of other country, without permission of central government. So these persons are disqualified from entering into contract. So the other condition was parties must be competent to enter into contract. All right, they must be competent to enter into contract. Fifth point was capacity or competency of party. The next one is lawful object. The object of agreement should be lawful and legal. Okay, so the purpose for which we are entering into agreement should be lawful and legal. If it is illegal, then Okay, some students are saying the screen is not visible, the notes are not visible. Is it so?
No, madam, it was visible.
It was visible, right?
Yes.
Okay. Yeah, all right. So the object of agreement should be lawful and legal. The purpose for which we are entering into contract must be lawful. Say, for example, the two-person enter into contract for killing someone, for murdering someone. The object of it is not legal. Then how can we call it as a contract? Say, for example, one person gave a contract of killing other person, some of his brother, and if that person kills and the other person doesn't give money, can he go to the court? No, he cannot, because here the purpose, the object is only unlawful. Court will not entertain such case, of course. Correct? So lawful object must be there. Then consideration. Consideration means something in exchange of something. The consideration must be also lawful. What we are exchanging. Same example I will use. That is, if I am giving a contract to kill my brother to a mafia person, okay, and I'm giving money for that. So one person is getting money here and other person is getting satisfaction of someone's murder. Here the consideration, both of us are getting something, that is called consideration. But what is it like? Consideration, one person is getting money and other person is getting satisfaction of someone's murder. So that is unlawful consideration, correct? Both of us are getting, one is getting money, theek hai, but other one is getting what? Satisfaction of someone's murder. That is completely wrong, correct? So unlawful consideration is also not allowed. So consideration must be also lawful. That is also one of the condition. Okay. What kind of consideration or object is said to be unlawful? You can see in the screen, 7th, 8th and 9th point. The consideration or object of an agreement is unlawful if it is forbidden by law or is of such nature that if permitted would defeat the provision of any law or is fraudulent or involves or implies injury to a person or property of another or court regards it immoral or opposed to public policy. First is when it is forbidden by law, means कोई भी law India के कोई भी law में अगर उसको forbid किया है, prohibit किया है, if the consideration or object is such, then we can say it is unlawful consideration or object. Then it is of such nature that if permitted would defeat the provision of law. Then also it would be unlawful consideration, that it is such object or consideration that it will not fulfill the provision of any law. Then third one, if the object of consideration is fraudulent, in such circumstances also consideration object will become unlawful. Then it is fourth one, it is involve or implying injury to person or property of another. The kind of example I gave, किसी और को murder करना है, we entered into contract of killing someone. Such kind of contract will imply injury to person of other or property of another. Then that is also unlawful consideration or unlawful object. And if court regards some act, object or consideration as immoral or opposed to public policy means against public welfare, then the object or consideration will be considered as unlawful. So these were the points regarding the lawful object and lawful consideration. We covered 6th and 7th point, essential elements of a valid contract. Then 8th point is certainty and possibility of performance. The contract must be quite certain enough. If it is not certain enough, if it is not possible enough, impossible hai jisko perform karna, then the contract will not be considered as lawful. And the next one is agreement not declared to be void. If there are certain agreements in Indian Contract Act which are declared as void agreements. If our agreement falls within that category, then it will be considered as void agreement. So our agreement should never fall within those category of void agreements. So agreement not declared to be void by Indian Contract Act, it should not be declared as void. Then only it will be considered as a contract. And last one, all legal formalities like stamping and signing and witness ka sign and all must be fulfilled while entering into contract. So these are some essential elements of valid contract. So now see this one. Essentials of a valid contract. As per section 10, all agreements are contracts if they are made by free consent of the parties, competent to contract, for a lawful consideration with a lawful object, and not hereby expressly declared to be void. So what we require for making a valid contract? Offer, acceptance, that is offer and acceptance when together is promise. Promise plus consideration is agreement. An agreement when enforceable by law, it results into contract. So this is how contract is made. Now the next one we'll understand is consideration in detail. I said to understand it in simple way, consideration is something in exchange of something. But what is lawful consideration? In the core meaning of it, in detail, if we understand consideration. So lawful consideration is all contract must be supported by consideration. Consideration means something in return, I said in simple language. And for that maxim, there is a maxim called quid pro quo. This can be also asked in your question, quid pro quo. Okay. So it can be in cash or kind or any act or subsistence, doing something or not doing something, that can be also covered in consideration. It can be past, present, or future. However, consideration should be real and lawful. A consideration must not be unlawful, immoral, or opposed to public policy. This we saw earlier. Not expressly declared to be void. Possibility of performance hona chahiye. When some act is considered as consideration, then there should be possibility of performing that act. Necessary legal formalities must be satisfied, and a contract may be oral or in writing. Okay. So, if I define consideration properly, it goes like, when at the desire of one party, you can see this in your books as well, when at the desire of one party, when at the desire of promisor, promisee, or any other person has done something or abstained from doing something, does something or abstains from doing something, promises to do something or abstains from doing something, is called consideration. Okay. So 3 things covered in this definition mainly. You can see in your book the definition in detail. When at the desire of promisor, I said as a first part of consideration definition. At the desire, consideration must move at the desire of promisor. What promisor wants, wo hona chahiye consideration. That should be the consideration. So when the consideration should move at the desire of promisor, first thing. Secondly, consideration can be moved by promisee or any other person, not necessarily by promisee only. On behalf of promisee, some other person can also move consideration. And thirdly, it can be past, present, or future. I said has done something or abstained from doing something, does something or abstains from doing something, or promises to do something or abstains from doing something. It's called consideration. So it can be past, present, or future. So consideration should move at the desire of promisor. Promisee or any other person can move the consideration, and it can be past mein consideration ho gaya and present mein the contract is entered into, the consideration is exchanged in present, and contract is also entered into the present, and contract is entered in the present, and consideration will be moved in future. This all three possibilities are there with the consideration. So here we have covered the major part of making the contract, the main ingredients required for contract. Okay. Now let us understand breach of contract. When the parties promises each other to do something and they do not fulfill their promise, they are said to make breach of contract. Okay. So what are the consequences of breach of contract? Let us understand that. Compensation of loss or damage caused by breach of contract. So one party, those who are making breach of contract, will pay compensation to other party. Second one, compensation of breach of contract where penalty stipulated for. If parties have beforehand decided in the contract itself that what compensation to be provided, then they will provide compensation as per the terms included in the contract. So that is the second one. So either court will decide the compensation, or parties have only decided in the contract itself the compensation to be paid in case of breach of contract, then compensation will be paid accordingly. And the last third one, party rightfully rescinding the contract. Rescinding the contract means cancelling the contract, entitled to compensation. So parties can also rescind the contract, cancel the contract. Okay. So that is also the remedy in case of breach of contract. These three things happen. Either court will decide the compensation, parties themselves will decide the compensation. If they have decided, then compensation will be paid accordingly. Otherwise, parties can rescind the contract, cancel the contract. Loss or damage caused by breach of contract. So compensation, as I said, court will decide the compensation. So accordingly, if there is a loss or damage to some property, then accordingly the compensation amount will be decided by the court. And if parties understand the value of the property which is broken or something, and beforehand they have decided the compensation, accordingly they will pay. Now, what do you require for valid contract? Elements of a valid contract. We saw this earlier. Offer acceptance, free consent of parties, consideration, valid contract, lawful object, competent parties चाहिए, that is major person, sound mind person, and not disqualified by law, and intention to create legal obligation. That I had given example of the teenager kid asking for sports bike. That example will be applicable for intention to create legal relation. Now let us understand the types of contract. Okay, someone had asked in the comment that how much portion syllabus will be covered in today's session. I had intention actually to cover entire commercial law. Contract is of course big one. It will take a little more time, and other ones will take relatively lesser time. But since there was a problem of connectivity so many times, I am not sure whether I'll be able to finish entire thing, but I will try my best to finish the most of the topics of commercial law today. And if I could not, I will continue it tomorrow. So I'll try at least 4 topics to finish 4 topics today. If I could not finish, then I will continue the remaining topic tomorrow. I will once again check because of the connectivity problem. I could not check YouTube comments again. I'll just check and answer them before moving to the other topic. Okay. Someone asked me, minor, unsound mind, drunken people, disqualified by law, educated, insolvent, and foreign ambassadors is not competent to contract. Is it right, madam? Yes, it is right. We are saying, but as I discussed in parties competent to contract, minor person, unsound mind person. See, drunken person will be considered as unsound mind person only, because when they are in the drunk position, they are not able to understand the consequences of contract and terms and conditions of the contract. They are not in the stable mind to understand that. That is why the drunken people will be covered in this unsound mind person part only, and disqualified by law may the insolvent person, foreign ambassadors are covered. So those are again not competent to enter into contract. That is true. Now, types. Let us discuss about types of contract. So, on the basis of creation or formation, the types of contract are express contract, implied contract. Express contract is expressly decided terms and conditions. Implied contracts are through circumstances, what contract we can understand, that is implied contract. Tacit contract is also by situation what we can understand, that type of contract. Quasi contract. Now, quasi contract you can see in detail in your books. You can open your books simultaneously. Quasi contract. Quasi contracts are enforceable by law contract, or we can say implied contract sort of only. That is, parties do not enter into offer, and they do not exchange offer, acceptance, bid and consideration and everything, but still the obligations are imposed on them just as if they have entered into a normal contract. So parties actually do not enter into contract by exchanging offer, acceptance, consideration, everything, but still the obligation is put on parties such that as if there is a contract. Such kind of obligation is put by the courts, by the law, on the parties. So that is what is quasi contract. I'll give you example of quasi contract. So when minors are supplied with necessities, minors when supplied with necessities by some relative, and he's orphan minor, okay, कोई उसके parents नहीं है, and relatives are supplying him with necessities, minors can those relatives who supplied with the necessities can recover the compensation of what they supplied from the property of minor if any. अगर कोई है minor के पास property तो उसमें से recover कर सकते हैं, otherwise not. So here minor and that relative has not decided into contract or by exchanging any offer, acceptance that I'll give you necessaries and you reimburse me from your property. ऐसा कुछ decide नहीं हुआ है minors के बीच, minor और relative के बीच में. But still court will put obligation. If relative wants a reimbursement, court will put obligation on the minor property, that from property of minor the relative can recover the reimbursement, the necessaries, the amount of necessary provided by them. Okay, so that is what is quasi contract. And some more types of quasi contract are discussed in length in the book. If you do not understand any, you can ask me in the comment. I will answer it. Next is on the basis of validity. So valid contract. Valid contract is satisfying all the conditions. Void contract is completely void. I mean, when we are saying contract is void, so void is when we are using the word contract. So contract means all the conditions are fulfilled. Then only we will call it a contract. But then later on it became void. So initially when contract was entered into, all the conditions were fulfilled. But later on one or more conditions ceases to apply. Then it becomes void contract. Third one is voidable contract. Voidable contract, as I explained earlier, when the parties, one of the parties' consent is not a free consent, that party will have option either to continue with the contract or cancel the contract, and that contract becomes voidable contract. Unenforceable contract means which cannot be enforced in the court of law. That kind of contract becomes unenforceable contract. Then illegal contract. Illegal contract means not having lawful object, lawful consideration. Those kind of contract will be considered as illegal contract. On the basis of execution or performance, that is, executed contract means already a promise is performed, fulfilled by both the parties, then it is executed contract. Executory contract is when the consideration or the performance of promise is to be moved or performed in future, the contract is yet to be executed, then it will be considered as executory contract. And the last one is on the basis of liability, bilateral contract and unilateral contract. Bilateral contract is when two parties understand the terms and conditions of the contract in the same sense with the same meaning. It is bilateral contract. Both the parties understand it to be same, with the same meaning, with the same intention, they enter into contract. Unilateral contract is only one party is asking or performing the promise and other one is not doing anything, only receiving. That kind of contract is unilateral contract, performed by only one party. Okay. So we have done the first part of our contract, the main provisions. Now we are doing special contracts. Contract of indemnity, contract of guarantee, contract of bailment, and contract of pledge. Here I have not covered contract of agency because of little time constraints, and contract of agency is very, very simple to understand. You can refer the module for it. Very simple to understand contract of agency. So contract of agency I'll explain little in detail and then I'll move ahead with these type other special contracts. Contract of agency is basically when there is a principal agent relationship between two. Okay, so when principal, one person appoints his agent means he is asking someone else to do his work on his behalf, then that is appointing an agent. So agent will have all the privileges, all the rights, not privileges, but all the rights to do whatever principal can do. So if I appoint an agent to do some work on my behalf, my agent will be able to do everything which I can do. So on my behalf, when he is doing some work, he will have all liberty to do things what I would have had if I myself would have been doing the work. So मेरे पास जो भी rights होते as a principal, similar rights my agent will also have. So such is the concept of agency, contract of agency. Here I am covering today only special contracts of contract of indemnity, guarantee, bailment, and pledge. Now let us understand contract of indemnity. First is indemnity. Very, very simple way to understand contract of indemnity is insurance contracts. The best example of contract of indemnity is insurance contracts. When life insurance contract or marine or fire insurance contracts are entered, what happens between parties? So the insurance company assures that in case of loss, in case of some problem, in case of injury or risk or loss, we will reimburse your loss. This is contract of indemnity. So contract of indemnity is basically whenever one party promises other party that in case of some loss or in case of some future event, we will reimburse your loss, we will make your loss good, we will pay you for your loss. That is contract of indemnity. Okay, so insurance company contracts with insurance companies are the best example of contract of indemnity. So here you can go to the definition of contract of indemnity. It's a contract of indemnity is a contract whereby one party promises to save the other from loss caused to him by the conduct of the promiser himself or by conduct of other person. So those situations in which they will reimburse the loss are discussed between two parties, and accordingly they will reimburse the loss. Now let us understand features of indemnity. So it must, of course, it is a contract. When I'm discussing special contracts, of course, it is also a contract. So just like normal contract, it must possess all the ingredients of a valid agreement, valid contract. It's a contingent kind of agreement. Contingent means based on fulfillment of some condition. So when I'm entering into fire insurance policy, there has to be fire, then only they will reimburse me with the loss. So it's based on the condition, that is fulfillment of condition is what? Fire must take place, then only they will reimburse the loss. So it's a contingent contract, that is to make good the loss. That is based on fulfillment of some condition, that is called contingent contract. Contingent is also conditional, we can say. The loss must be caused by human conduct only, and loss must have actually been suffered. Then only they will indemnify the loss. Parties to contract of indemnity. See, motor insurance, marine, fire insurance, this kind of insurance. Indemnity contracts examples are there. Rights of indemnity holder when sued. So indemnity holder means when we enter into contract. If I enter into contract with insurance policy for fire insurance, so I am indemnity holder and insurance company is indemnifier. Okay, what are they called? The insurance company is indemnifier, and the party who's taking the insurance policy is called indemnity holder. So whenever there is a fire in my place and I ask for the reimbursement, the indemnification of my loss, and they do not pay it, then if I sue them, if I file a case against them, what do I get? I get damages. Damages here means, in law language, damages means compensation. Okay, here damages does not mean loss. Damage is loss, but damages means compensation. Then all cost, whatever cost I have incurred in filing the legal case or everything, I will be getting the cost of it. I will have right of asking for the cost. And third one, all sums. Any sums, any for repairing work after fire, whatever I have incurred the amount, the sums for everything, I can get it back. Now, rights of indemnifier. Indemnifier means the insurance company in my example. The Contract Act is silent about the rights of indemnifier. Okay, Contract Act में कोई cover नहीं हुआ है indemnifier के rights. So we are done with contract of indemnity. Let us start with contract of guarantee. Meaning and definition. A contract of guarantee is defined by Indian Contract Act. A contract to perform the promise or discharge the liability of a third person in case of his default. A guarantee may be either oral or written. Simple. So it is quite similar to indemnity, but here we are saying that if one party will not pay, I will pay on his behalf. That kind of guarantee is given in contract of guarantee. Okay, so here a simple example is debtor, creditor, and surety relationship. So when debtor, creditor, and surety relationship is there, debtor takes the debt from creditor, and creditor promises, surety promises the debtor that if you could not pay money in future to the creditor, I will pay on your behalf. That is what is contract of guarantee. Okay. Essentials of a contract of guarantee. Existence of a principal debt. There has to be some debt between two parties, that is debtor and creditor. Then consideration for a contract of guarantee. Okay. Now, as I said, these are special contracts will also require all the ingredients of the normal contract. So consideration is the very, very important ingredient of contract. So consideration will also be required in contract of guarantee. Now, what kind of consideration? See, debtor is getting money here, that he's getting money. Creditor is getting promise from surety that if he could not pay, debtor could not pay, surety will pay. So creditor is also getting something. So here main contract is between debtor and creditor only. So consideration, if both of them are having, that is enough. Surety के पास कोई consideration होना चाहिए, ऐसा necessary नहीं है. Okay. Then there should be no misrepresentation or concealment. Yes, this is very, very important part, because here there is a duty to speak. If something is hidden from creditor or debtor, from creditor, by debtor or surety, then the contract will be void there and there only. Okay, and if there is some arrangement between creditor and debtor, and something is hidden from surety, then surety will also not be willing to pay on behalf of debtor. So nothing should be hidden, concealed from surety as well. So there should be no misrepresentation or concealment. Then contract of guarantee must contain all essential elements of a valid contract. I said this already. And contract of guarantee is complete and separate contract by itself. So it's a full-fledged contract. Types of guarantee: special guarantee and continuing guarantee. Guarantee is a specific guarantee if it is intended to be applicable to a particular debt and thus comes to an end on its repayment. Okay. So special guarantee is only for one specific transaction. If guarantee is given by a surety to creditor that if debtor could not pay, I will pay. Once that debt is over, if debtor has paid, then special guarantee will act. Continuing guarantee. Continuing guarantee is for a lot of transactions, for many number of transactions. Okay, a guarantee which extends to a series of transactions is called a continuing guarantee. Example: fidelity guarantee. Fidelity means that this person will be faithful. He will perform his contract. Here, the money is not involved. Here, it is about the faith and trust. So, whether the contract will be performed, the business contract will be performed or not. So one person surety gives the promise, the guarantee to the one of the party to the contract that this other party will definitely perform the contract. You can trust on me, like that. So fidelity guarantee in writing, legally they give. And then overdraft. Overdraft is a bank, the transaction with the bank, the overdraft facility that you can take from the bank. So that is continuing guarantee. Rights of surety. So against the principal debtor, rights of subrogation. Right of subrogation, very interesting thing to understand. See, there are a lot of rights covered in your module, but this I have covered in my slides because these are some ones which you may not be able to understand, and which I feel is very important to explain. So this I have covered in the slide. Beside this also, there are some other rights of surety, which is very simple to understand, that you can understand from the book. So right of subrogation. Subrogation is when surety pays to the debtor on behalf of creditor. Surety himself becomes creditor. He comes in the shoes of the creditor. Okay, for the debtor purpose. Okay, so if surety pays on behalf of debtor to creditor, creditor is out of the picture. He got his money back. So he is out of picture. Now the things are between debtor and surety. Surety, of course, paid on behalf of debtor. So he will recover from debtor his money, correct? So he will then take his money from the debtor just like creditor. So he becomes creditor. He becomes like creditor for the debtor purpose. Okay. So here that is subrogation, right of subrogation, that he gets all the rights of creditor now. Right to indemnity. That is when surety pays on behalf of surety pays on behalf of principal debtor, and because of that surety suffers any loss, debtor is in the duty to indemnify him the loss, make the good loss. Then right of surety against creditor. So right of securities. If a debtor has given the guarantee of surety also and kept some of his assets as a security with the creditor, say that is, if he could not pay, the assets could be sold and the creditor can recover money from that. Then once debtor surety pays on behalf of debtor, those securities, those assets become security of surety now. So he can recover that from creditor, those securities. Right to claim set off. Set off of what? Set off of the debt, of course. When surety pays to the creditor, he can take the same amount from the credit. He can claim set off from the creditor. Next one is against the co-sureties. When several co-sureties have given guarantee for the same debt with their maximum limits, they are liable to pay equally but subject to the limits they have fixed. So if there are more than one surety, say for example, if there are 4 sureties, okay, so everybody will share 25%. So if one surety has paid entire amount of debt on behalf of debtor to the creditor, he will recover rest of the 75% from other 3 sureties. Okay, so he had to pay 25%. He paid entire 100%. So other 75% he will recover from other co-sureties. The next contract is special contract of bailment. Very simple to understand. Contract of bailment. Before giving you the definition, making you understand the definition, I'll give you a simple example. Example, I bought a dress material and I went to a designer for stitching. Here, I have some movable property. Okay, my dress material is my movable property. This dress material, movable property, I am transferring to the designer. Okay, I'm transferring to the designer. Here, my movable property is transferred from me to the designer for stitching purpose. For what purpose I have given? For stitching purpose. With a condition that once stitching is done, he needs to return me the dress, right? And I will pay him for that. So both of us are getting here something. I am getting the stitched dress, and he is getting money. So this is contract of bailment. Now you can understand bailment through this example very well. Bailment is a delivery of goods by one person to another person. Here in my example, from me to my designer, for some purpose, upon a contract that they shall, when the purpose is accomplished, be returned. With that condition, I have given my dress material to the designer that once it is stitched, the purpose is accomplished, he should return that to me, or otherwise disposed of according to the direction of the person delivering them. Or I can also direct the designer saying that you give this dress to my sister once it is stitched. Okay, so I can ask that also. The person delivering the goods, in this example, I am the bailer, and the person to whom goods are delivered, that is designer, is called bailee. So is everybody clear with the bailment part? One person giving some movable property to other, transferring movable property to other with a condition that once purpose is achieved, goods shall be returned. That is bailment. See essential and legal rules as to bailment. Delivery of goods. The goods must be delivered. It's necessary. It's important to be delivered. No transfer of ownership. Now when I'm giving to designer, I am not giving ownership. I'm just giving for stitching purpose. Delivery of goods for some purpose, stitching purpose. Return of specific goods, that is after it is stitched, it should be returned. It has to be movable goods only, movable property only, goods only. And deposit of money into bank, or I'm giving money directly to this designer, I'm transferring money to the his a bank account, like that. And here deposit of money into bank is from other angle as well, that is in locker if I deposit money, or if I'm in my account if I deposit my money, here the bailer and bailee relation will take place. Money is also kind of movable property over here. Okay, so when I'm depositing the amount with the bank, I am giving for some purpose, and with interest I will get it back, that from that angle. Kinds of bailment. So on the basis of benefit, bailments exclusively for bailer's benefit, like that also. Bailer's benefit means only bailer will get something, bailee will not get anything, no consideration will be he will be getting, only one-sided, we can say. Bailment exclusive means if designer is my friend and she is giving me stitched dress, I am getting benefit, I will not pay because my friend, she is my friend. So only for exclusively for bailer's benefit, we can say this one. Bailment exclusive for bailee's benefit. Opposite to this, if I'm giving someone my property to use, if example I'm giving my friend my car, okay, use it for 1 month, so only bailee is getting benefit. I'm not going to take any money for that. So bailer is not going to get anything here. Bailment for mutual benefit, both the dress designers example is fit for this. Both of us are getting something, money and the dress. On the basis of willingness, voluntary bailment. So when parties voluntarily do it, it is voluntary bailment, and when parties do not do it voluntarily, it is involuntary bailment. I mean, involuntary is because court asks them to do, they do it, or like that, not on their own. Then on the basis of reward, gratuitous bailment. Gratuitous means free of charge. That is, when I said example of giving my car for a month to my friend, gratuitous bailment. I am not going to get any money. Only she's going to enjoy and for free. So that is gratuitous bailment. But with the condition that once it is used for 1 month, she should return it to me. So that is how it is bailment. Non-gratuitous bailment is basically contractual bailment, the one which we understood about the dress designer example. That is contractual. Contractual means consideration involved. Both of us are getting something. So that is non-gratuitous. Non-gratuitous one is also called as contractual bailment. Rights of bailor. Rights of indemnity for losses. Abhi, simple to understand. When bailor is giving his goods to some other person, so if any losses occur because of bailee, so he should get indemnification, the reimbursement from the bailee. उसने अगर कुछ loss किया है bailor का तो, then termination of bailment on inconsistent use by bailee. If bailee use it for his own purpose, the bailor's goods, then bailor has right to terminate the contract anytime. He can take his own goods back. He can cancel the contract anytime. Compensation for unauthorized use by the bailee. If unauthorized way mein bailee is using bailor's goods, then he can cancel the contract also, and he can ask for compensation as well. Compensation when the bailee mixes the goods bailed with his own goods. Similarly, unauthorized way mein bailee used his own, mixed his own goods with the bailor's goods. So of course he will have to pay compensation to the bailor. Right of return of goods back. Once it is the purpose is over, or if purpose is not over and unauthorized use is made, then also in both the situations, bailor will have right to ask for his goods back from the bailee. Right to profit from goods bail. And if because he has given goods to bailor, say for example, I have a cow and I am going out of station, and I give my friend, I'm giving out of India for 6 months. I give my cow to my friend saying that you take care of this cow for 6 months, and once I'm back, you give it back to me. So and during that time, cow gives birth to a calf. Okay, so calf is a profit. Okay, one more cow is come. Okay, so that profit, when I come after 6 months, of course I should take that profit. So both the cow and calf, I can take it back. Duties of bailor: to disclose false and goods bail. Yes, so bailor, whenever giving goods to bailee, if any defect or any risk involved in the goods, he should inform that to bailee. To repay the necessary expenses, if some because goods, to take care of the goods of the bailor, bailee had to incur some expenses, then bailor is under duty to pay those expenses. To indemnify the bailee, if bailee suffers some loss because of the risk involved in the goods of bailor, then bailee has all right to ask for the loss, the reimbursement of loss from the bailor. Liability on premature breach of bailment. If there is any premature breach of bailment, that is before time, if bailment is ended, and because of that bailee is suffering some loss, bailor is under duty to pay that off. So these questions, rights of bailor, duties of bailor, then this kinds of bailment, and the entire bailment short note, these kind of questions can be asked to you directly in your exam. Other special type of contract is contract of pledge or of pawn. Pledge is an extended form of bailment. Very simple way to understand is pledge is an extended form of bailment. So when I said in bailment, one person transfers his goods to another for some purpose, with a condition that once purpose is achieved, goods shall be returned. Now here I said for some purpose, means for any kind of purpose, goods can be transferred from bailor to bail. Okay, it can be for any purpose. But when I talk about pledge, it is for one specific purpose. That is the main difference between bailment and pledge. That is, in case of bailment, for any purpose it can be given. The goods can be transferred from bailor to bailee. But in case of pledge, the goods are transferred from one person to another for one specific purpose. That is to serve it as a security against debt. If I am getting money, I am taking money from someone, and if I give my goods, movable property, as a security to other person from whom I am getting the debt amount, then that is called pledge. Simple way to make you understand. अगर हम हमारा, if we keep our immobile property, our flat or our building or something like that, residential property, as a security, as a mortgage against a debt amount, so that is called mortgage. But if we keep movable property against debt, if I am taking loan from somewhere and I am keeping my jewelry, my ornaments as a security with that person, I'm transferring my movable property to him to serve it as a security against debt. I am making pledge. Is everybody clear with this? Pledge is basically bailment ka extended form, transferring movable property from to another person to serve it as a security against debt. Here the parties are called pledger or pawner. Matlab bailor, the one who will transfer the goods, will be called pledger or pawner, and to whom it is transferred, it will be called pony or pledgee as well. Now, essentials of pledge. Delivery of goods. It's necessary. Delivery of goods should be by way of security, means as a security against debt, and goods must be movable, compulsorily movable property only. Rights and duties of pony. Right of retainer. That is, until he gets the debt amount back, he can always retain the goods with him. Okay. Right of particular lien. But lien, here lien word, this also was asked in your mock test. If you see anybody who has not solved mock test, I suggest everybody must solve mock test before giving the exam. So here, there in the mock test, if you see one question of lien is asked. What is lien? Lien. Lien is right to retain the possession of goods. You can note down in your books. Lien means right to retain the possession of goods. So here, right of particular lien means the goods which is pledged with him, सिर्फ वही goods वो रख सकता है, to retain that goods. Right to extraordinary expenses. If any expenses had to be incurred to take care of the goods of the bailor, if the pledger, if any expenses incurred by pony, he can recover that. Right, in case of default of the pawner, if he do not pay, and because of that, whatever interest was charged or everything, he can recover from the pawner. Rights and duties of pawner. Right of redemption. Once he pay back his debt amount, he can redeem his goods from the pony. Right to take back the goods. Yes, similar thing. Now, pledge by non-owners. This is very interesting to understand and very important also. Understand it properly. Pledge by mercantile agent. So here, it is not that only if you are owner of particular goods, you can pledge it. Okay. So generally we understand, if I want to keep my ornaments as a security against that, it has to be my ornaments. I cannot take away someone else's. I cannot commit theft of ornaments and then keep it as security. Of course, I'm supposed to be the owner of the ornaments. So only by ornament or by the owners, the pledge can be kept. That is a general rule. But there are some exceptions. In these cases, even non-owners, even if you are not owner of a movable property, you can pledge it. First is mercantile agent. So when the agent is working on behalf of principal, he can, even if the goods are of principal, not his goods, he can put that as in a pledge against, for the benefit of principal. Agent can use principal's goods to take loan and keep it as a pledge, but of course not for agent's personal use, for principal's benefit only. Then pledge by person in possession under voidable contract. So under voidable contract means, as I said, when the consent is not taken by free consent, the contract becomes voidable one. So until the decision is made whether to continue with the contract or cancel the contract, until then, if the goods are with the buyer, say for example, seller sold the goods, seller's consent was taken with the fraud, and seller sold the goods and delivered it to buyer already. But then later, seller decides to cancel the contract. But before that, buyer has put it as a pledge with someone else. Until it was decided, buyer has put it as a pledge with someone else. Then that kind of pledge is allowed, pledge by non-owner, even if he's not the owner. Pledge where owner has only a limited interest. Owner has limited interest means he's a co-owner, means say for example 3% is owning a movable property, and he has a 33% share. So a 33% share, that much share for share, that much share amount, he takes the debt and he puts his part on the pledge. Then pledge by co-owner in possession, similar thing, and pledge by seller or buyer in possession after sale. So sale has happened, so buyer has become owner, but still goods are not delivered. Buyer has become owner, but he has paid price maybe, but goods are not delivered, and it's still with the seller, and still seller keeps it as a pledge, then it is allowed. So such kind of pledges also allowed by non-owner. So here we are done with our Indian Contract Act part. I'll quickly address the questions, if any, asked by you. I'll just check. Okay, a lot of questions. I'll address all the questions one by one. So a lot of question about the link. So link is sent on the WhatsApp group. I think other students have answered that already. 10 to 1, yes, my lectures would be 10 to 1 every day. Today some connection issue, so I think I am not visible because I'm just using one instrument for this purpose. So YouTube and both the things I'm not able to connect. So and I'm sharing screen also, so my face is not visible. But from tomorrow onwards, I'll make sure my connection is good, and I'll continue. I'll the screens and everything is seen properly. I'll make sure that I'll answer your queries quickly, and then we'll move to another topic. So you can get the link in your WhatsApp group for next 2 days. My lectures are there from 10 to 1. Someone asked, ma'am, why are mock test question pattern are half? Dear, there is no clarity, Mr. Satyam Shirke. You have asked this question. There is no clarity as to the pattern yet from the institute. So mock tests are also made accordingly because of this COVID issue. Still, the things are not very clear. That is why mock tests are that way. But whatever mock tests are available, I suggest everybody should give that. Okay, someone has asked Deepa Pawar, explain again contract of indemnity in short. Okay, dear, and a very, very simple way to understand contract of indemnity, as I said, is its best example of it is insurance contract. So when you enter into insurance policy, LIC, life insurance policy, if you go and enter, okay. So or fire insurance policy or marine insurance policy. So fire insurance policy, if you enter, what is it like? That in case there is a fire at your place or at your office, we will reimburse you with the loss. जो भी नुकसान होगा, जो भी loss होगा, we will reimburse you that. And for that, abhi se you need to pay little premium. So that is how the contract of indemnity between them. Deepa Pawar, are your query answered? Is your query answered? I mean, do you understand contract of indemnity now? Okay, Omkar Patil is asking, what is the difference between quasi and contingent contract? Okay, contingent contract is basically conditional contract. That is based on fulfillment of some condition. So it is normal contract where offer, acceptance, and consideration is exchanged between parties. Okay, it is like a normal contract where offer, acceptance, consideration, everything they exchange, but based on fulfillment of some future condition. That if this thing happens, then only the performance of contract will happen. So like that, based on some future condition, the contract is based. That is contingent contract. Now, quasi contract is completely different. Quasi contract is when there is no offer, acceptance, or consideration exchange between parties, but still there is some responsibility, some obligation is put on the parties as if there would have been contract. तो कैसा responsibility होता? तो वैसा ही similar responsibility, because there is some legal provision, ऐसा responsibility आता है. So quasi contract में I gave you example of minor getting reimbursement, minor getting some necessary supplied from the relative. So one relative is, say for example, there is one minor who does not have parents. Okay, उसके parents नहीं है और उसको उसके relatives are supplying with the necessities of life, food, clothing, shelter, education facility, and medical facility. So later on, if that minor has properties, the relative जितना भी उसने amount spend किया इसको necessity supply करने में minor को, that amount can be recovered from the minor's property. Of course, personal obligation could not be put on the minor, but from the minor's property, if any, if minor does not have any property left, then nothing can be done. But if minor has property, it can be recovered. The amount of necessity supplied can be recovered from the minor's property. All right. So that is quasi contract. Here, minor and the relative never decided between each other that you give me necessities, I will give you reimbursement from my property. Nothing like that decided. But still, relative get that right because there are some legal provision like that. So because of minor property, this obligation is put to give the reimbursement to the relative because legal provision. So that is quasi contract. So Omkar, is your query answered? And I have one more question. Is my screen, when I was explaining entire contract act, is my screen visible? Was it visible? Because actually there was connection issue, so I doubt there was. There was some issue with the screen. Do you think it was proper? I mean, सब लोग को screen बराबर दिख रहा था when I showed the PPT? You can write in the comment box. I can see if it was visible or not. Please, someone answer so that I can go ahead with the other topic. Okay, Priyanka Agarwal. Thank you so much, Omkar. I'm glad that you understood what I explained. I'm glad you understood what I explained. Priyanka Agarwal, you want me to help you with register and get the link. Actually, I am not the right person to help you with that. I think later on you can ask the coordinator to tell you. Vanzari sir, please help this Priyanka Agarwal question. She wants to register and get the link. So please help her with that so that she can join the class. Vanzari sir, can you hear me?
Yes, madam.
हाँ, सो ये प्रियंका अग्रवाल मैडम बोल रहे हैं कि उनको ये लिंक जरा चाहिए रजिस्टर करने में हेल्प करना प्लीज.
लिंक चाहिए उनको. But
हाँ.
she is on the line now. She is online. She is seeing the video on all. Then why she wanted? Which link she want now?
Priyanka, what link you want? You please message in the chat box.
Because she is already live and she is watching the video. So what else she want?
हाँ, exactly. Mehak Goyal has asked me, ma'am, can you please explain section 26 void agreement? Yes, definitely. As I had mentioned, I've not gone into detail of that because since it's a crash course class, I was little faster with the Contract Act. I will definitely answer section 26. So, in the Contract Act, there are some agreements declared as void agreement. Okay, so those agreements are declared as void agreement because even if all the other conditions of contract like offer, acceptance, consideration, parties competent to contract or lawful object, lawful consideration, everything else are fulfilled. Okay, but still some contracts are declared by Indian Contract Act itself to be void. Okay, so when our agreement falls in that category, it will be remain void agreement only. It cannot be considered as enforceable by law and it cannot become a contract. Okay, so section 26 is one of that, agreement in restraint of marriage. So there are a list of agreements like agreements in restraint of marriage, in restraint of trade, in restraint of legal proceeding, lot of wagering agreement. So all those agreements are declared to be void. That agreement in restraint of marriage is basically when one person enters into agreement with the other saying that you are not supposed to get married or you don't allow your daughter to get married, otherwise I will not give you this amount or whatever, like that. So that is, if any agreement is restraining someone's marriage, some major person's marriage rights, okay, after you turn 18 you have right to get married to anyone you want. Okay, if that right is restrained by entering into agreement, that is void agreement, even if offer, acceptance, constitution, everything else is proper, but still this agreement is void, declared by Indian Contract Act. So Mehak Goyal, do you understand section 26 now? So similarly you have to understand other void agreements as well. Satyam Shirke, mock test question paper up to 3B. This also I am not much aware. I will check it and I will let you know tomorrow. Definitely I will check about this, why the paper is up to 3B only, and what is the reason because of for that. I will let you know tomorrow about this. Okay, Manjari sir, Priyanka Agarwal is saying that she wants to register to attend class in Zoom. I'm watching, she's watching YouTube
Okay,
live.
ask her to send one email. Email ID I have provided just now. I will provide the link.
Okay. So Priyanka Agarwal, can you hear that? You need to drop an email and then link will be sent to you. So someone is asking, is the PPT shared after sessions? See, PPT will not be shared after session. This will be live. This is a YouTube session only. You can watch it anytime you want later also. So you can see PPT from there. I need not share it. All right, let us move ahead with, we do not have much time. Let us move ahead with the other topic, that is Sale of Goods Act. Okay, let us start. Sale of Goods Act 1930. Again, very easy act. Earlier this act was part of Contract Act only, but later on different act in 1930 of sale of goods was made. This is also again very old law. Before India became independent, this law was passed. So introduction, essentials of what we will cover in today's Sale of Goods Act topic. So essentials of a contract of sale. Distinguish between sale and agreement to sell, conditions and warranties, doctrine of caveat emptor, rights of unpaid seller, delivery rules regarding delivery. So these things we will cover in Sale of Goods Act topic. This you can go through quickly, history of sale of goods. This may be useful to you in your for your MCQ questions. Okay, let us go ahead with the definition. Now, when we are learning about Sale of Goods Act, two words or two terms are very important in this act. That is goods. We are learning about sale of goods. So, of course, you need to understand very well what is goods. And those type of questions are also asked a lot. So, what is goods? And one thing is that, and what is sale? We are understanding about Sale of Goods Act. So, sale and goods. These two terms you need to understand very well. Section 4.1 of the Indian Sale of Goods Act defines a contract of sale of goods in the following manner. A contract of sale of goods is a contract. We already learned about contract. So all the ingredients of normal contract must be satisfied here also. Okay. So contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So what all things are required? First is transfer property in goods. Property in goods means, everybody note down, property in goods here means, in legal term, it means ownership in goods. Ownership regarding goods. So contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods, that is ownership and rights of goods, to the buyer. And other necessary thing what is required is for a price, not for free. If it is not for a price, if it is without consideration, it will not be considered as sale. Okay, so a contract of sale of goods required a contract first of all, a proper contract where all the conditions of contract is fulfilled. Then transferring of ownership in goods, property in goods. And third thing, from seller to buyer. And fourth thing, for price, that is some consideration has to be there. So here again I say, as I said, all the essentials, at least two parties, agreement to transfer ownership, contract must necessarily be regarding goods. Here what is goods we'll understand in little while, but it has to be regarding goods. The consideration is price. And a contract of sale may be in writing or by words, that is oral or writing, that is fine, or not compulsorily to be in writing. And all of the essentials of valid contract must be present. Now, as I said, two terms you need to understand very well in this act: goods and sale. So let us understand what is goods. Goods means every kind of movable property and includes stock, every kind of movable property, okay, except two. Only money and actionable claim is not covered in this definition, or everything else is covered. So all movable property, anything you can move, that is even grass and crops which are attached to earth, but definitely before sale you can sever it from earth, you can detach it from the earth, that it is considered as goods only. So only except two things, everything, all other movable property are goods. So that those exceptions are actionable claim and money. You can go through this definition. Goods, very simple. Every kind of movable property includes stock, shares, growing crops, grass, and things attached to or forming part of land, which are agreed to be severed before sale or under the contract of sale. Actionable claim and money are not included in definition of goods. Of course, money, your cash, currency, is also a movable property, but not included in the definition of goods. Other thing, actionable claim, this you might not be able to understand. I'll explain. So, actionable claim is basically any debt for which you can file an action. Okay. So, anything you have right to claim and for which you can file an action is called actionable claim. So, this is also movable property. In writing, if it is written that you I if in writing someone has given me that I owe you this much money, 5,000 rupees, of course I can claim it in by going to the court, but I cannot deliver this paper of saying that I owe you 5,000 rupees to anybody else to claim it as actionable claim. Okay, so it cannot be transferred as goods, so it's not considered as goods. Types of goods, three types of goods: existing goods, future goods, contingent goods. Existing goods means the goods which are in present, by looking at them, by observing them properly. But after that, the sale order is given to the seller. Okay, so buyer asks the seller for it, existing goods, by checking it, after checking it. So physically in existence. Okay. Future goods, it is yet to be made or manufactured. Okay, it's not there in present, but by just looking at the sample or something, goods which are supposed to be manufactured in future or produced in future are for that agreement is made. So that is future goods. See example, it will clear your understanding. Then contingent goods. Here again, as I earlier explained in the Contract Act, the meaning of the term contingent, it is conditional. Okay, so contingent means conditional. So conditional goods, that is in future, depending upon some future condition. Though type of future goods, that the goods of acquisition of which by the seller depends on some contingency, that is some happening of some event in future. Okay, so seller ke paas, already seller doesn't have it, seller is going to get it in future, and that is also depending upon some condition. So simply seller is going to manufacture it on his own, that is simple future goods. But seller is also going to get from someone else, and that is also depending upon some condition, that is called as contingent goods. Two examples are given, it will clear your doubt. Okay, let us go ahead. The term contract of sale of goods is a generic term and it includes sale and agreement to sale. Very, very important. A very much favorite question also. A lot of questions have been asked in past on this topic. With the two things you need to understand now. Sale, S-A-L-E, sale, and agreement to sell. Now, these two things are also different. Okay, contract of sale covers two things. Agreement to sell and sale both. It includes both the things. The sale means when the sale is complete, when property in goods is passed from seller to buyer. That is sale. Property in goods means ownership in goods. So ownership in goods is passed from seller to buyer. That is when sale. That is the transaction complete. That is sale. S-A-L-E, sale. But when agreement to sell means when property in goods is not transferred, but they are agreeing that it will happen in the future. So that is agreement to sell. Sale and agreement to sell distinguished. So as simply you can understand, sale is a complete act, complete contract, and agreement to sell is not a complete thing. It's yet to happen in the future. Okay, so distinguish also given very well in your modules. Also, you can see distinguish regarding that, and very simple to understand the distinguish given, and quite favorite question also. It's asked also a lot. See here in this slide, one rectification, one mistake is there. In the when it is agreement to sell is explained. First in first line, it's a contract of sale. Likha hai, it's by mistake. Here there agreement to sell will come. Now you can see the example to better understand it. Other point of difference between sale and agreement to sell. See, in sale, the fourth point is a little technical. I'll explain that. Seller cannot resell the goods because the contract is complete. Even though seller still has goods, the physical goods, but property in goods, the ownership in goods has passed to the buyer already, because sale, when we are saying sale, the entire contract has happened. So property in goods is passed from seller to buyer. So then seller cannot sell the goods. But in case of agreement to sell, it is yet to happen. The property in goods, the ownership in goods is not passed yet. So seller can still sell the goods to other party, to third party. So if you, it's very simple to understand once I explain this sale and agreement to sell, these distinguished points. But any point if you don't understand, you can write me in the comment section. Okay. Now, which documents are considered as documents to title to goods? Now, title here, I explained property in goods means in legal sense ownership in goods. Here, one more legal term, title. That also means ownership. Okay. Title means ownership rights. So, which document shows ownership rights regarding goods? Okay. So, a document of title to goods may be described as any document used as a proof of the possession or control of goods, authorizing or purporting to authorize either by endorsement or by delivery the possessor of the document to transfer or receive goods they are thereby presented. So, when through document of title to goods, you get the right to receive the goods or right to transfer the goods to other person. The following are documents of title to goods. Bill of lading. If I'll explain one or two in this, you will understand rest of them also. So bill of lading. Now, if my goods are going by ship to Chennai, okay, from Mumbai to Chennai, if my goods are going through ship, now I have a when I'm sending goods through ship, no, they give me a proof that my goods are loaded in the ship. For that purpose, they give me proof called bill of lading. The first thing written here. So bill of lading is a proof, and now I'll scan the bill of lading copy to my employee in the Chennai, and taking that bill of lading, he will be able to receive the goods from the Chennai port. So this is bill of lading. Bill of lading shows the title regarding goods, that we have ownership rights or rights, basically rights to receive the goods or possess the goods. Okay, so that is bill of lading. Now similarly, dock warrant. Dock, if it is kept in the dock, then you get a receipt called dock warrant. When it is kept in warehouse, you get a receipt called warehouse keeper certificate. So by showing that, whoever has that receipt will be able to receive that or possess that. Then war fingers certificate is also similar. Railway receipt, if you are sending goods by railway receipt uh, you need to have to receive the goods. So similarly, okay, so these are document of title to goods. Now, before going ahead, I'll just quickly answer your queries, if any, regarding contract of sale and agreement to sell. Avneet Thakkar, you're asking grass is including in goods? Yes, of course. I've mentioned that grass is included in goods in the slide. Because it is some kind of goods. Before selling it, you can sever, you can detach it from the earth, and then you can sell it. So before sale, if something can be detached, it is considered as movable property, and it will be covered in goods only. Which item excluded in goods? Money and actionable claim. That is already explained in the slide. Sale of Goods Act 1930 is still not applicable in Jammu and Kashmir. Mehak Goyal is asking question. No, it is still not applicable in Jammu and Kashmir. For that, Parliament needs to amend the act and make it applicable. By removing the section Article 370, all the acts are not automatically applicable on Jammu and Kashmir. Now only new acts can be made by the Parliament. That is what happens by removing Article 370. All right, let's go ahead. Let us start with conditions and warranties. Very interesting, because sale of goods is something we also do in our daily lives. Obviously, not in, if not on bigger level, like in business, more units and all. But one, two things, so we also keep buying. So warranties and all, you also hear this term quite often, and it's you are also familiar with this one. But I am very sure that in legal sense, what does warranty mean? From that angle, you won't be that clear. Because guarantee and warranty, this is what you hear when you buy some product from the market or from some mall or something. But here warranty means something else. When we are talking about contract of sale, okay, sale of goods, when you enter into a contract, then the condition and warranty is something else. So in simple terms, let me explain you first, then we'll go in the depth of the definition. Conditions means primary conditions, okay, uh, which is necessary for main purpose of the contract and main fulfillment of the contract. If those things are those conditions which are very very necessary and which is of primary importance uh, for the contract, if that is breached, it will result into the contract being cancelled. It can result into contract being cancelled. So those important terms are considered as conditions. And secondary conditions, I will say warranty ke liye, that when the conditions are of secondary importance, some other kind of conditions which are not of primary importance but some other kind of conditions, non-fulfillment of which will not result into cancellation of contract, but party may have right to um, take some compensation, take some damages for that purpose. So that is warranty. Okay, so what you hear about warranties and all, okay, you buy a laptop or you buy a TV or you buy a sofa, you have warranty of this much years. So that is different. So warranty means they may give you compensation or repairing charge, or they may repair you for that. So that is warranty. That is how you hear. But here in legal sense, what does it mean? That secondary importance wali conditions, breach of which will not be which will not make you which will not allow you to cancel the contract altogether, but that is you will not get entire money in full refund nahi milega, but what will happen, you will get just compensation. Okay, so that is warranties. uh, a condition, you can read the definition of it, very simple. Now to understand, condition are something very very important conditions, non-fulfillment of which will give rise to repudiation of contract. Repudiation means cancellation of contract. And the warranty one, the meaning of a condition, it's essential for the main purpose of contract, breach of which will give party a right to terminate the contract, repudiate the contract. It goes to the root of the contract. Sound fulfillment upsets the very basis of the contract. So those kind of main conditions, primary conditions, that it will make the entire contract uh, you know absurd, or it will upset entire contract. Example, if I buy a laptop and it is I bought a laptop online, it came with entire crushed screen. Okay, and there are two three buttons missing from the panel, then this will not serve my purpose only for of buying laptop. So it is going to the root such main thing, that of course I will cancel the contract, I will ask him to take it back and give my money back, right? So this is something, is main condition. And warranty, and the stipulation collateral to the main purpose of the contract, that is secondary, okay, kind of, or subordinate kind of purpose of the contract. So for secondary importance, if there is a breach of a warranty, the aggrieved party can only claim damages and it has no right to treat the contract as repudiated. So that is condition and warranty. Again, quite favorite question. काफी बार पूछते हैं question. You can go through this case as well. And whenever condition warranty question is asked, you can support your answer by writing this case. Next, condition distinction between condition and warranty. Very important distinguishes that, okay, condition is primary importance and warranty is a secondary importance condition. And other main distinguishing point is, because of breach of condition, entire contract can be cancelled. But in case of breach of warranty, entire contract cannot be cancelled, only damages compensation can be claimed. So that is the main points of difference. Express and implied conditions and warranties. So express and implied conditions means expressly stated conditions, and some conditions are and warranties are implied, if not stated directly, but through circumstances you can understand it. Expressly decided between conditions, then it is express condition. If not decided by parties, but it is understood by its own through circumstances, that is implied conditions. So implied conditions are such conditions as to title. So if I am buying something, I'll get ownership right over it. As to title means ownership right. So it is, even if not expressly decided between parties, it is obvious that if we are entering into contract of sale of goods, I'll be the title to goods I will only get, ownership rights I'll only get. So that is a implied condition. Then these other ones are discussed through cases which are there in your module. You can understand that by reading those cases. So like sale by description. So if sale by description is made, means if I have described that I want such type of goods, and if then it doesn't turn out to be that way, of course I have right to cancel the contract. So description match hona chahiye, like that. Condition as to quality of fitness. Of course, even if it is not decided between parties, if it is not fit product, or if it is broken or not not fit for my purpose, it's clearly mentioned if I want it for this purpose, and if it is not fit for my purpose, it is, even if it is not decided between parties, of course I have right to cancel the contract. Conditions implied by custom. So there are some customs in the business. If since generations those kind of customs are followed in business, and if some conditions are implied because of that, that is even if not decided by parties in the contract, but because of there is custom ke ye to pata hi hoga, party they both are tend to know that, then they, even if they do not mention in the contract, it is an implied condition. And sale by sample. If sale is by sample, then the quality should match the sample. If I've seen some sample and I've said that you make the goods same exactly like this, and the goods doesn't turn out to be that way, I have all right to cancel the contract, even if it is not expressly decided. condition as to wholesomeness. Of course, wholesome hona chahiye, toota futa, broken. It shouldn't be broken one. So even if not decided, these are obvious things which can be understood. So these are some implied conditions. Then implied warranties. Warranties can also be clearly stated expressly, and it can be implied as well. So implied warranties are warranty of quiet possession, that nobody will disturb my possession, nobody will come and one day tell that this belongs to me, you give it back to me. So this is a warranty that so I should have a quiet possession. If I do not have, and if someone bothers me with the possession, I will not be able to cancel the contract, but what I can be doing is I can ask for compensation from the seller. Warranty against encumbrances. Encumbrances means defects in the goods. So mortgaging or something like that. So if the goods which I'm buying is already mortgaged to someone else, okay, pledged. When I'm talking about goods, of course, it is pledged. It's not mortgage. So it is pledged with someone else. Okay, say for example, I'm buying some shares, but the seller has pledged it with someone else. So even the pledgee will have right over it. So when I'm buying, I will believe that there is no encumbrances. किसी और का भी ऐसा वो defective नहीं होना चाहिए. Title, the seller must have full ownership rights over it, and he's transferring full ownership rights. So when there is some pledge or something like that, it's called encumbrances. So of course, I will expect that there will not be any encumbrances, but it turns out to be later, then I can only ask compensation. I cannot repudiate the contract. So these are implied warranties. Warranty to disclose dangerous nature of goods, of course. Even if it is not expressly decided by between parties, but if party is failing to disclose the dangerous nature of goods and it results into some loss to the buyer, he can ask for compensation. Then warranty as to quality of fitness by usage of trade. So the business is of such type that the goods are of particular quality of fitness, and if it doesn't turn out to be that way, uh, the buyer can ask for compensation. So these are implied warranties. Before going to the next one, I think the time is about to get over, so I'll quickly answer your queries, and then maybe we can continue tomorrow with the session. Someone has also asked in the comment section when I'm starting with the company law. As soon as as soon as I complete commercial law, I'll quickly start with the company law. So maybe tomorrow only I'll start with the company law. I'm almost done with sale of goods. Little only is left, and then partnership and LLP and negotiable also I'll quickly finish tomorrow in first half. Today there was a lot of disturbance because of net problem. Tomorrow I believe there won't be any problem, and in first half, 1.5 hour, I'll finish the commercial, and then other half I'll start company law. All right. I'll quickly answer queries. I'll just check. Sanil Patel, you have a question as cash and actionable claim. Acha, you are answering Avni Thakkar. All right. Any other questions, guys? I can quickly answer them. Write me down. You have 5 minutes. I'll quickly answer whatever I've taught today. If any doubts are there in that. Any question, guys? I believe everybody is clear with entire Contract Act and sale of goods, whatever I've taught till now. So no questions up till now. I'm waiting for 2 more minutes. If you have any queries, you can write me down. I'll answer them quickly and we'll continue tomorrow then. Okay, then I'll Manzari sir.
Yes, madam.
Yeah. Can I sign off now? I mean,
Yes, madam. Thank you.
I'll continue. Yeah, I'll continue tomorrow then.
Yes, yes.
So same time.